Hi, I'm Joe Simons and I'm a federal criminal defense attorney. If you're in federal court facing charges with a mandatory minimum sentence, then that means the judge cannot sentence you to anything less than that amount of time. For example, if the crime that you're charged with carries a 5-year mandatory sentence, that means the judge cannot go below 5 years, even if he or she wants to, except in a few circumstances. Now, some of those circumstances involve ratting or providing substantial information against co-defendants or other people. I'm not going to talk about that here, and I'm not a fan of that. The other option, though, is what they call the safety valve, and that does not require ratting, that does not require governmental approval, meaning that the prosecutor doesn't even have to agree. But if you qualify for the safety valve, that is a way that the judge can give you a lesser sentence than what the mandatory minimum is. To qualify for a safety valve in federal sentencing, there has to be 5 criteria met. First of all, you must not have been the leader or organizer of the crimes or charges that you were involved in. You also cannot have an extensive criminal record. You must not have used violence in the commission of the crimes that you're charged with. The offense must not have resulted in serious bodily injury. And prior to sentencing, you must tell the government everything that you know about your commission of the crimes and related acts. There are perhaps hundreds of federal crimes that carry mandatory sentences, and among them, drug offenses seem to be the most common. Low-level drug dealers often qualify for the safety valve as long as there's no violence and as long as they don't have a significant criminal history. There are some exceptions to that. For example, crimes that occurred near a school playground or a public housing facility might not qualify for a safety valve sentence. In order to qualify, you must not have more than 4 criminal history points. You must not have a prior 3-point offense on your record. And you must not have a prior 2-point violent offense on your record. Prior sentences for adult or juvenile crimes that result in less than 60 days of incarceration count for 1 criminal history point. If you had a prior offense that resulted in between 60 days and a year of incarceration, that counts for 2 criminal history points. Offenses that occurred while you were in prison or while you were on supervised release or probation also count for 2 criminal history points. Prior sentences of more than 1 year and a month result in 3 criminal history points. But then there are further nuances. For example, if you had 3-point offense that was more than 15 years ago, that wouldn't count. If you have a 1 or 2 criminal history charge on your record that was more than 10 years ago, that doesn't count. There's a number of little exceptions where it's helpful to have a knowledgeable federal criminal defense attorney explain given your specific circumstances. If you're facing a federal criminal charge with a mandatory sentence and you want to explore the possibility of pleading the case but avoiding the mandatory sentence, you might be eligible for a safety valve sentence. Talk to your lawyer if you have one, and if you don't, feel free to give us a call today.